Hello and welcome to another presentation. In this presentation I'm going to talk about, is it legal to record conversations in the UK? The law generally dictates that there are some exceptions when you don't need the court's permission to record a conversation in the UK. Here are the key points. Personal use. Under the regulation of investigatory powers, RIPA 2000, it is lawful to record conversations without permission if the recording is intended for personal use only. This means you can record your own conversations without informing the other party or seeking court permission, as long as you keep the recording private. Now, many people are being harassed or told by certain court officials and or lawyers that they can't record their own court case. I would suggest everyone check into the law here that I've provided, the regulation of investigatory powers, to see if it would apply to them. Now, for business purposes, businesses are allowed to record conversations without informing the customers or seeking permission in certain circumstances. These include proof of a transaction, to ensure compliance with regulatory procedures, to prevent a crime related to telecom systems, which are phone systems, to maintain quality standards for national security interests, public interest. Journalists can publish secret recordings without legal repercussions if they can prove the release of the recording is in the public interest. This exception is typically used to expose scandals, corruption, and other wrongdoings of high-profile individuals. Public spaces. In truly public spaces, such as parks, squares, and streets, you are generally allowed to film without permission. However, this does not apply to private property that may seem public, like shopping centers or airports. It is important to note that while recording without permission may be legal in these cases, sharing or distributing the recording without consent can still lead to legal issues. Additionally, even if recording is made legally, its admissibility in evidence in court may still require permission and be subject to certain conditions. Remember, these exceptions primarily apply to personal and specific business uses. In most other cases, especially those involving legal proceedings of official matters, it is advisable to seek proper authorization or court permission before recording a conversation. Well, given the fact, and this is my own opinion, it's not legal advice, given the fact that you are trying to prevent wrongdoings of high-profile individuals such as judges or other court staff or your opponent in your legal proceedings, you may wish to record in order to get a proper transcript. I was involved in a court case in Toronto where the judge sealed the court case even though it was a simple civil claim, and there's no legal precedent for him to do that. And if I didn't have the recording in another court case in Belleville, I wouldn't be able to prove the professional misconduct and criminal wrongdoing by not only court staff but also by the plaintiff and the plaintiff's lawyer in that case. And since we want to get this as evidence that we can use, and I sent it to the Canadian Judicial Council, who conveniently ignored it. So one is aiding and abetting the other. But if you don't record your court case or your phone call or your conversation, then it becomes your word against theirs as to what really transpired. Therefore, I would suggest everyone get a phone recording device and or a personal recorder with a separate clip-on mic. What about recording in a court case in the UK? Recording a court proceeding without permission is prohibited by Section 41 of the Criminal Justice Act, or so they would have you believe, and Section 9 of the Contempt of Court Act 1981, which again they would have you believe. I'm here to tell you that that information is incorrect. Now, if we look at this thing, we have the Courts of Justice Act 1925, and it says right in here, no person shall take or attempt to take in any court a photograph or with a view of publication, or attempt to make in any court any portrait or sketch of any person being judge of the court or junior or witness to the party, any proceedings before the court, whether civil or criminal. Publish any photograph, portrait, or sketch taken, made in contravention of the aforegoing provision, this section, or a reproduction thereof. So it's dealing with photographs. Doesn't have anything to do with audio recordings. Any person conversation shall be on summary conviction liable in respect of each offense to a fine not exceeding £50. For the purpose of this section, exception court means a court of justice, including a court of a coroner. Now, including is restrictive. If we go back to the language and look it up in Merriam's Law Dictionary, and then it says the expression of a judge includes a recorder, register, magistrate, justice, and coroner. Photograph, sketch is deemed as a photograph, portrait, or sketch taken or made in court if it is taken or made in the courtroom or in the building or the precedence building in which the court is held, or if the photograph, portrait, sketch is taken or made of a person while entering or leaving a courtroom of any such building or the aforesaid. But if you deliver a document and they won't give you a receipt, then by all means take a picture of it when it is sitting on the desk of the court clerk's office or the court registrar. I had such a case in Magistrates Court in Lancaster, and they would not provide a receipt, and I simply told the guard, well, how do I ensure that they actually state they got it or prove that they did get it if they state anything to the contrary? So I took the photograph and told the person with me to take a photograph, and we walked out of the court. If they have nothing to hide, then what's the problem? Right? You're only proving that you served the document and proving that somebody signed for it. If they won't sign for it, how else are you going to prove that they got it? And many times they give you these court restrictions in hopes that you can't serve them on time, and then they have a way out to prevent you from getting a fair chance at justice. And if we look here at the use of tape recorders, and this here is under the Contempt of Court Act 1981. If you look at the number 4, because I'm not going to read the whole thing, this section does not apply in making use of a sound recording for purposes of official transcript of proceedings. Well, if you want to turn around and use these transcripts, you're going to have an audio recording to do so. So then you take your audio recording and submit it to a certified court transcriptionist, and that will get you around this loophole. Again, if they have nothing to hide, what's the problem? I'm currently working on a book regarding council tax. If you wish to be notified when it's complete or have any other comments or questions, I can be reached at the email on the screen. And if you wish to make a donation via PayPal, the same email address works. Thank you for your time and consideration in this short presentation. I hope you found it helpful or useful. If you are involved in a different type of court, such as family court, I suggest you would check the regulations. But under the last one I gave you, just get it transcribed and you should be all right. When I presented this to a lawyer representing the Lancaster City Council, the lawyer ran away because they had nothing to nail me on. I'll give you one piece of free advice. Know the law and be well disposed to use it, because if there's a loophole, they're certainly not going to tell you. Thank you and have a good day.